We've been talking a lot, of course, about Bill 96 recently, getting closer and closer to becoming law as opposed to Bill 96. There is a rally tomorrow, of course, to protest this, a variety of sectors across the province. Not just individuals, not just angry phones who are against this, but everyone from the Quebec Bar Association to Quebec doctors have weighed in on this, to small businesses. And some of the issues they're going to have to confront because of this if it goes through the way it is right now. Pearl ELIADIS is a lawyer and McGill University law professor. She's on the line right now. Pearl, I know you were quoted the other day in a story, and I wanted you to just go through this because I think there is sometimes this idea that we're complaining about this and we are therefore just complaining about language issues. But with respect to business in this particular bill, in Bill 96, there are some big irritants here in terms of what it will pose for business owners, are there not?
Yes, there are a number of, of course, protecting language extends to protecting the language of work. So in that sense, it applies to business, and it's going to affect everything from recruiting to advertising to the language in software to whether or not you can require a person to be able to speak a language other than French. And, of course, there are provisions with regard to search and seizure and quite extensive penalties.
How much different, then, is this than what was already in Bill 101?
So all of what I said is either different or new, or it takes it to a new level. So, for example, the new powers of search, seizure, and inspection, as well as the penalties that are attached to that, are all brand new. And, of course, the provisions dealing with the fact that all of this is going to come into effect notwithstanding the Canadian Charter of Rights and Freedoms, and, by the way, notwithstanding the Quebec Charter of Rights and Freedoms, of Human Rights and Freedoms, is also brand new.
There are also a lack of details, I guess, in this, and this is something that bothers a lot of companies, manufacturers, for example, exporters. This idea that you will now have to show, what do they call it, all reasonable means before demanding that an employee speak English necessarily for that particular job. What's all reasonable means?
I have absolutely no idea. Reasonable. Look, reasonable is one of those words in legal statutes that you use to make it clear that the government has to behave reasonably, and that means things like not being arbitrary and having reasonable limits on things. But the problem is that the reasonableness requirements are not subject to any constitutional scrutiny or limits, so the ability to assess what's reasonable and what isn't doesn't have any real controls attached to it. And really, the government can come up with its own reasons as to what it thinks is reasonable, and there's very little in the way of measures to control or to challenge those decisions. So it really is going to depend on either regulations or policies that the office puts in place or other parts of government put in place to decide how it's going to work.
Now, I just have one other question, which is this idea where, and you said in the past, they could still come into your office, right, and check to see that you're operating in French, depending on the size of your business. But with this new bill, assuming it goes through the way it's written right now, you no longer have the right to say that the office, for example, came in illegally and seized your items?
You no longer have that right. So, Canadian constitutional law since 1982 has been that you have a constitutional right to be free from unreasonable search and seizure. It's a mystery to me why restricting anybody's constitutional rights is necessary to preserve the French language, or the ability to seize their documents is necessary to preserve the French language. And then when you go to court and you try and defend yourself, you're not going to be able to file your pleadings in English without a certified translation. If you have difficulties in court because the judge doesn't speak French or doesn't understand you, you may be out of luck as well. And the ability to challenge the penalties that come from all of this, which would normally be in part a product of a constitutional protection against unusual forms of punishment or treatment by a government entity, those are gone too. So it's all across the board.
I think what I'm imagining here, if this is really going into effect, the search and seizure, and they're taking computers and data and whatever it might be, doesn't that ostensibly shut down the business? How does the business even continue to function?
Well, it's not entirely clear to me that they can actually take the computers themselves.
Okay.
I think that's a matter of interpretation in the statute, but certainly they can take or cause other people to provide them with all documents and relevant information without any warrant and without any reasonable grounds whatsoever. And that is a problem. And I know that defenders of the bill have said, well, you shouldn't be concerned about this because the government has no intention of being punitive towards business. Mm-hmm. And that's a little bit like saying, well, we don't really need a Charter of Rights and Freedoms because we trust the government and we trust the police and we trust law enforcement to do the right thing. The whole point of having the rule of law and legal structures and protections in place are to make sure that citizens, people living in Quebec, have the ability to challenge them when the government makes mistakes, and the governments do make mistakes. And it's really, I think, it's hard to overstate this. It's really stepping back from the fundamental values that the international world order has put into place about what human rights means since the Second World War.
I wonder as you go through the ramifications in this bill, I mean, depending on what the government chooses to apply or the office chooses to apply or not, I wonder to myself, and it's been brought up before, there are businesses that will simply say, look, you know what? We're a small business. Maybe we're 20 or 30 employees, and now we're going to be subject to this. It's just easier for us to pick up and leave than be subjected to this, or at least face the threat of being subjected to this. Have you heard that from anyone? I mean, is that something being discussed?
No, I haven't heard that. And I want to also make a slight adjustment, Aaron, if I may. It's 25 or more, not 20 or more. I think the important thing here, though, is not that businesses may or may not leave. They may, and certainly that did happen in the past. But I think we need to remember that a lot of small businesses in Quebec really have their roots here. Mom and pop shops, small restaurants that are, rooted in the community. And really what you're going to do is to make their cost of doing business significantly higher, often without any real rationale. And that, to me, is the punitive part, and I think that's the part we need to be concerned about.
I'm thinking at this point it's pretty much a foregone conclusion that Bill 96 is going to go through, and with the notwithstanding clause, we know where we're headed with all of this. Once it does go through, where does that leave us? Are we stuck with it until a new government is elected?
Well, I think what's going to happen is that there are going to be constitutional challenges, just like there was with Bill 21, probably like there was with Bill 21. The plaintiffs will lose at first instance because the courts will really consider their hands tied. So then it's going to have to go all the way up to the Supreme Court of Canada, which may or may not decide that the Quebec government has finally gone too far. And if that fails, then you have recourse to the international community. But that's a long haul.
Yeah, I was going to ask how long a haul. How long a haul is that? Is that years?
And is it being enforced in the interim?
The answers in order are yes and yes. I mean, so it is being enforced in the interim because the likelihood of being able to ask for a suspension is minimal, meaning, and we saw this with Bill 21, the parties tried to ask for a suspension of the law until, it went up the ladder, and the court said no. So Bill 21 is still in force. I'm guessing that the court may treat it, kind of the same way. And then, Aaron, in terms of your question about timing, it takes years to go. You'd have to have the trial, you'd have to have the hearing, which could happen in a couple of years. Bill 21 happened, in that time frame, and then it's like another year if you're going to go up to the Court of Appeal, and then you've got to go, then you've got to ask for leave, or if you have an appeal of right, depending on the nature of the case.
What a
go
mess.
to the Supreme Court of Canada, another couple of years. So the best thing I think to do is to argue with the international community that because the constitutional remedies have been eliminated, that with respect to those remedies that have been eliminated, there's no point in asking the parties to go through the whole thing when we know it's a foregone conclusion, and to ask the international community to make a decision in the interim. But I'm speculating at this point. This would be something we'd have to see based on the first decision.
Wow. Long road anyway you slice it to hoe. Pearl, thank you so much for your time. I very much appreciate it.
Thank you.
Have a good weekend.
Pearl ELIADIS, lawyer, McGill University law professor.
It's so discouraging.
It is, isn't it?